Hello and welcome to PPL 518 Alternative Dispute Resolution 2. This is Dr. Francisca Anene, and this is our second lesson. In this lesson, we'll be looking at the benefits and burdens of arbitration. We'll mention a number of arbitral institutions, the popular ones, and then we will also look at the laws that are applicable to arbitration in Nigeria. So let's continue with our lesson. If you were in the last lesson, let's just go over it. If you remember, we looked at general definitions of arbitration. Remember, we said that the ACA does not have a definition, and we said why. The ACA clearly did not want to limit um, the definition of arbitration. However, we looked at Brown and Marriott, we looked at Oxford, we looked at words and phrases legally defined and Halsbury's laws, and we mentioned the fundamental features of arbitration, and we compared between Professor Schmidt's view of arbitration being better than litigation and contrasted it with Fouchard, who was of the opinion that arbitration was rudimentary. What we're going to be looking at is comparing arbitration with litigation in order to draw out the benefits of arbitration and any burdens. And then we will talk about some arbitration institutions that we know and the laws that are applicable to arbitration, particularly in Nigeria. Compare. When you say that arbitration is better than litigation, some people will say yes, some will say no. So usually, if the disputes are just within, the um, location and parties, the stakes are not so high. Some parties may prefer to go to court and save themselves the cost of going to arbitration. Although it's not in all cases that arbitration is expensive. But consider where a dispute is of international proportions involving multinationals from different countries. If you look at, for instance, the P&ID case that has been on for the past, the case has been decided, but the appeal that has been on for the past, year or so, is a multinational dispute. It consists of, the parties are Nigeria on one side and P&ID, which is a company that was registered in the British Virgin Islands, which actually is owned by an Irishman, and arbitration was carried out in London. Parties went for arbitration in London when a dispute arose, and during the arbitration, an award was made against Nigeria, and P&ID went to enforce the award in the US. So you can see four countries. For such a dispute, litigation may not be the best option. Then also consider the fact that for specialized issues, disputes that require particular expertise, there may not be the judges with that particular expertise as to be able to do justice to the case. And then, of course, you know that with each location litigation, the court system is a matter of sovereignty. The rules that apply in Nigerian courts may not apply, do not apply in American courts or in British courts or whatever. Each system has its own legal, political, and ethical rules, which they will not be ready to throw away and adopt another country's system. Then, of course, there's the rigidity. Everything is clearly defined. You must file your pleadings within this time. You must file your defense. You must reply and all that. That is sometimes a problem with litigation. Then, of course, the time it takes, particularly in Nigeria. An average dispute, there was a study done which found that for a criminal case, which is supposed actually to go faster because of the fundamental rights issues involved, for a criminal case, sometimes cases go cases may go on, awaiting trial. Accused persons may be remanded in custody for minimum, on the average, about 4 years before their case is tried. Okay, sometimes it takes much more than that. So those are the issues with the court system and why we need to look at the benefits of arbitration. So institutions that we know. There are many, there are many. I must point that out. But these are just a few to give you an idea. And this will be your homework. I'll talk about that much later in the lesson. You will go and find out about more arbitral institutions and come and tell us about them. So, but what you have to note is that International Chamber of Commerce, London Court of International Arbitration, WIPO Arbitration Centre, ICSID, these are some of the major ones. And WIPO has to do with intellectual property. So there's a likelihood that you would have intellectual property experts in that center. So a party that has intellectual property issues is well advised to go to WIPO. Parties are not forced to use institutional arbitrators. Please note, it doesn't mean that if you don't go through institutional arbitrators that your proceedings are invalid. That doesn't matter. Parties can decide to choose by themselves who the arbitrators are, who the personnel will be, and all that. But you must consider the cost and then consider what are you saving vis-a-vis what you're losing. And that is what informs the choice sometimes to use an international. So, local, again, there are many, but we actually want to point out the Lagos Multi-Court House because it is a success story in Nigeria and now in Africa. Something that started so small, has grown so much that you now even have in Lagos State, you have what they call the settlement month. So that month, parties are um encouraged to use the multi door courthouse, seek resolution of disputes out of court, mediation, conciliation, arbitration, whatever. And another fantastic thing about the multi-door courthouse is that other states have now started to emulate. So you have multi-door courthouses in other. And then, okay, so this is your homework. As I said, find out about local and international arbitral institutions. Find out and tell me their names and tell me what you think their area of expertise will be and all that. Two international, two. Okay. So the question now is, why use arbitral institutions? Why not go and get your arbitrators by yourself and save yourself the cost? First thing is that arbitral institutions, they have their rules, and so you don't have to. Everything is laid down, and it's a guide. Parties are not bound to follow their rules. Well, at least if parties are minded to make rules, there's already a template for them to work with. Then add to that the fact that arbitral institutions have all the personnel that they need already, working there, trained and ready to offer their services, as against where the parties, would have to start shopping themselves for personnel. Same for arbitrators. Usually, institutional arbitrators have people of good repute, people reputable, experts in their field that they can readily call on. That's not an option that a party who wants to do it on his own will have, because there's the chance that even if he knew who to call, the person he would want to be an arbitrator may not be disposed to sitting on that particular panel. So that's it. And then expertise, I've talked about expertise and I gave an example of the WIPO Arbitration Center and intellectual property matters. But note that, as I said, arbitral institutions can be expensive because the payment is, there's nothing like let's negotiate. Payment, there's a scale of fees and payment is usually made beforehand. There's a deposit put down beforehand before they even start working. And most of these arbitral institutions, particularly international ones, they charge in dollars. So you can imagine if you were to exchange how much. In this lesson, what we have basically done is to trace the benefits of arbitration. Can you remember them? Let's go over them again. Flexibility, confidentiality, expertise, um, expedition, what else? Please, I need to point out something on flexibility. Parties, the arbitration cannot be so flexible as to um, exclude the rules of natural justice. They are fundamental rules of natural justice. These are not statutory. They are rules of nature, laws of nature. They rule against bias, personal bias. That is nemo judex in cosa sua, and then the rule for fair hearing. Flexibility cannot be used to exclude that. Okay, so that's all that we have for today's lesson. Remember your homework. Go and find out two international arbitral institutions and two local arbitral institutions. And I'll see you during our discussion class on Wednesday. Please try and look at the question and make your contribution. To be nice to read from you and know how well we're making progress in the course. So good day and good week, and see you. And let me just mention, there will be I've scheduled, and I will send you the email with the link. We're having a Zoom meeting on Thursday at 8:30 p.m. We will have the Zoom meeting, basically discussing what I have said, to give you the opportunity to interact, to make it interactive, so I'm not just talking over you. Okay, so I'll see you during our discussion forum. I'll see your comments and I'll be happy to look at them, and then I'll see you on Wednesday during our Zoom meeting. So have a good evening and bye.